Hi and Assalamualaikum. For today, I am going to share with you guys about my cybersecurity case law review. Before that, thank you Madam Shayu and all my fellow friends. My name is Muhammad Hairul Anwar bin Muhammad Masri, your presenter for today. So for today, I am going to share with you guys about the case which is Nur Ridwan bin Haji Muhammad Ali dan seorang lagi lawan Suhaila binti Muhammad from Mahkamah Tinggi Kuala Lumpur on 30 March 2019. We go to the next slide which is fact of the case. So for the fact of the case, the plaintiff has filed this action because he argues that the defendants have falsely accused the plaintiff by writing on the social media Facebook as well as the WhatsApps. The second plaintiff and the defendant are siblings, where the second plaintiff is the older sister to the defendant. The first plaintiff was the husband of the second plaintiff and the brother-in-law of the defendant. Both of them owned a business. In a Facebook posting dated February 27, 2017, after the defendant apologized and demanded a car loan repayment that was refused by both plaintiffs, and after the second plaintiff challenged her. So through the WhatsApp's application, date 22nd to 25th February 2017, via personal message by the defendant to the second plaintiff, which was later had been forwarded by second plaintiff itself into the family WhatsApp group. According to the plaintiff, these words are slanderous because they are not true. The plaintiff demands that the defendant apologize to the both plaintiffs publicly, posting an open apology on Facebook, send an apology message via WhatsApp, advertise apology in Malay language daily newspaper, and pay ringgit Malaysia 1 million for the damage caused. This happened when both plaintiffs used their money to pay for a family vacation ticket to China. This vacation joined by the plaintiff family and the defendant's family. The defendant was late to pay back to the plaintiff. On February 22nd, 2017, the defendant, as known as SD1, has asked her brother-in-law Faiz to pay to the plaintiff. At this moment, the car issue had already been raised, and this has made their relationship even worse. Regarding the car, the first plaintiff sold to the defendant for a price ringgit Malaysia 20,000 and on a monthly basis payable directly to the bank under the plaintiff account. The payment of ringgit Malaysia 20,000 was paid by the defendant and was accepted by the plaintiff, followed by the defendant paid to bank every month. The defendant also never failed to pay the bank for 8 months at ringgit Malaysia 1,000 per month. So the amount paid by the defendant is ringgit Malaysia 20,000 plus ringgit Malaysia 8,000 equal to ringgit Malaysia 28,000. Since the plaintiff has taken back the car, the defendant has deemed plaintiff necessary return at least ringgit Malaysia 20,000 to the defendant immediately and not in discretion talk as the plaintiff claimed. But the plaintiff has still failed to pay the defendants to this day. At the same time, the plaintiff still made the plane ticket worth only ringgit Malaysia 3,500 as an issue. Okay, so we go to the issue discussed. The issue that were discussed on this case is on our law on libel, which is governed by the Defamation Act 1957. The burden of proof lies on the plaintiff to show, first, the words are defamatory, second, the words refer to the plaintiff, and third, those words were published. We go to the next slide, which is the judgment of the case. So, for the judgment of the case, the court is satisfied on the balance of probability that, first, the plaintiff failed to prove that the statement or word on the defendant's Facebook page have slanderous words or statements, though they are abusive, because the statements are true, stated that both plaintiffs have a debt with the defendants. Second, the defendants have succeeded in bringing their defense of justification because this statement may not all be true, but they are largely is true. As a conclusion, the court ruled that plaintiff actions or claim rejected at a cost of ringgit Malaysia 5,000. So, as a conclusion, I am very agree with the decision that had been made by the court because of the plaintiff cannot prove that the statement or words on the defendant Facebook posting is a slander. Because on Defamation Act 1957, in order for the plaintiff to prove that he or she was slandered, she has to fulfill the three elements that were stated on the Defamation Act 1957. The Defamation Act 1957 was formulated by the government to protect the interest, reputation and image of a person or organization from being damaged or harmed as a result of inaccurate writing. In this case, both plaintiffs admit that the defendant already written the card and they have to pay ringgit Malaysia 20,000, but they did not pay to the defendant and that were called a debt by the defendant. The plaintiff also the one who shared the private message that was sent by the defendant to the family WhatsApp group. The defendant is the one who can file the case because when we look at the fact of the case, the defendant has a strong point to win the case compared to the plaintiff. So that's all from me. Okay, this is my references, and thank you very much for listening and watching this video. I hope that my sharing will give you a knowledge about what actually happens on this world. So thank you for watching. Bye. Assalamualaikum.